Major breaking news out of the state of New York. A federal district court judge has shut down an attempt by the state of New York to delay the inevitable loss they are going to experience over New York's assault weapon, quote unquote, assault weapon ban. You're not going to want to miss this breaking news in the case of Mark Lane versus James in New York in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About Our Right to Keep and Bear Arms. All right, folks, breaking news. We know there's a quote-unquote assault weapon ban, propaganda term, assault weapon, right? Anything can be an assault weapon, a spoon, a fork, a lamp, a brick, okay, a rope. Nevertheless, New York likes to call bans on semi-automatic rifles, the most popular rifle in U.S. history, the AR-15, bans on these kinds of firearms, semi-automatic rifles, to be assault weapons. So they call it an assault weapon ban. Well, that assault weapon ban is being challenged in the United States District Court for the Southern District of New York in a case called Mark Lane versus James. And this challenge to this obvious violation of the Heller rules, because AR-15s are in common use by Americans for lawful purposes to the tune of tens of millions of people own these things. This is being challenged. And New York knows they're in trouble, and they're on their heels. We know that because the motion to dismiss filed by the state of New York was denied, and now they're moving toward getting ready for a decision on the final judgment. Usually by what will happen here, I suspect, will be cross motions for summary judgment, meaning that based on all the facts and what everyone agrees to be the facts, New York will say that the AR-15 ban in New York is constitutional. And the plaintiffs will argue, of course, that under the Heller test, the AR-15 bans in New York is unconstitutional under the Supreme Court precedent of Heller and the text of the Second Amendment. So New York must realize they're in trouble on this point because they filed a major request in front of the federal district court chair, Judge Kenneth Karras. And the request was, please, Judge, please, pretty please, Judge, we want to stay this case, which means we want to delay this case, slow the case down. We want this case to be delayed until there's a decision in a year or so in another case involving Connecticut's, did you hear what I just said? Connecticut's quote-unquote assault weapon ban that's in front of the Second Circuit Court of Appeals now. So please don't rule on this New York case. Of course, every single day that goes by is another day where that New York assault weapon ban is in effect. And you can go to prison if you have the wrong kind of gun. And if you want to buy the gun that you're allowed to buy in the other 46 some odd states across America that you're allowed to buy these firearms in, you will go to prison if you do that in New York. So I'm happy to report that the lawyers for Mark Lane and for James Sears filed a very powerful opposition, which I'll put a link to down below, and I'll play some of it here right and now, saying that, hey, no can do, this is totally wrong. You, Judge, should make a decision on this case as fast as reasonably possible, and then we'll take it from there. So the Second Amendment lawyers argued, quote, there are several reasons why a stay should be avoided under these circumstances. First, the Second Amendment right to keep and bear arms is a fundamental right, which protects an intangible and unquantifiable interest in personal protection and self-defense that cannot be compensated by damages. The loss of plaintiffs' rights is irreparable. Here, plaintiffs' fundamental rights are being infringed by defendants' enforcement of New York state laws, and it is inequitable to require plaintiffs to endure a prolonged delay in vindicating their rights while someone else's case concerning the laws of another state, in this case Connecticut, works its way through the time-consuming appellate process. Powerful language there. And I'm happy to say that Judge Karras has denied the request for a stay. So what the judge did is he got this letter, which I read part of it to you, and then he says he's endorsed it, meaning he signs this letter called a memo endorsement on this letter, which is called the letter in opposition to stay filed by James Sears and J. Mark Lane. And what he writes on the letter, or endorses the letter, he writes the following. The court will not impose a stay. Defendants are to explain, and the defendants are New York State. Defendants are to explain in a letter due by January 30th, 2024, what discovery they need and how long they need to obtain it. Plaintiffs are to respond by February 2nd, 2024. So ordered. Now, what this means is basically this is putting the burden on New York State to say what discovery you want in this case. Doesn't seem like you need very much. I mean, what exactly is it that you need? I mean, there's no dispute that the plaintiffs here are law-abiding Americans over the age of 21. So, there's no kind of games that can be played with that. So what exactly do you need to figure out? You banned the guns. You already presumably have all the information you need about the guns you banned because the legislature banned the guns. And you're representing the New York State because you're the New York Attorney General's office. You already have all this information about the guns. You presumably have already vetted it internally and did the internal memos to figure out is it constitutional or not. And you said it is. So what other information do you need? You already had to sign off on this allegedly unconstitutional act that you think is constitutional. So it doesn't seem like a lot of discovery of the plaintiffs or anything else will be warranted. But we'll see what they say on January 30th when they submit their letter to this case. So you may ask, why is this such a big deal? Keep in mind, as you know, that the U.S. Supreme Court really wants to hear cases on the final judgment. So the sooner we can get to final judgments in as many Second Amendment-related cases as possible, including the quote-unquote assault weapon bans, like AR-15 bans, which we're dealing with in New York and in Connecticut and these other places, the faster we get to a final judgment, the better it is, because the sooner the Supreme Court will be able to take it. Now, you may be asking me, why are we covering a denial of motion for stay by the state of New York? And it's because you ever watch any of these war movies and you see all these men getting killed to try to take over an island or a rock or a ridge or a bridge, and you're thinking to yourself, how many men have to die to take over a single bridge or a single rock or a single cliff or whatever it may be? And the reality is those are often very important steps to ultimately winning the overall war. So sometimes here on the Four Boxes Diner channel, I want to cover these major victories, which are major battles that we've won that ultimately can give rise to winning the ultimate war. And today is an example of this, because had New York been able to procure their stay and delay the decision in the Lane versus James case for over a year, that would have made it much harder for us to get this case, for example, to the U.S. Supreme Court. And as you know, it is clearly the goal of anti-gun judges and anti-gun litigants all across this great country to delay any future or further Second Amendment cases before the Supreme Court until after Justice Alito or Justice Thomas leave the court and get replaced by Joe Biden pick. That is their ultimate goal. They're trying to delay, and hope that the Supreme Court gets changed either that way or through a court packing scheme or some other way. So that is why delay is the battle plan of the anti-gun left. And our battle plan and goal on the pro-Constitution, pro-Second Amendment wing of America should be to push as many cases as fast as possible to the U.S. Supreme Court while we have this current court. Because if you fill this court full of a bunch of Justice Brown Jacksons, well, in addition to the fact that you probably won't know what a woman is anymore, you certainly won't have any Second Amendment rights. That will be the ultimate outcome. So there you have it. All right, folks, hope you learned something here today. Make sure you follow me on X at 4Boxes Diner and subscribe and resubscribe, because people keep getting knocked off, I'm told. So make sure you subscribe and resubscribe to this channel, and hope you learned something and enjoyed. And we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.